Dr. Alan Littler, who is gaming lawyer at Kalff, Katz in Franssen, who is going to tell us more about the monopolies in the Dutch gambling market. Alan, welcome. Thank you for being here again, and the stage is all yours.
Thank you, Willem. Thank you. Okay, thank you for the introduction, Willem. I'm going to talk today about a decision of the District Court of Oost-Brabant from the end of February this year, which indeed could upend the monopoly-based supply of several land-based forms of gambling in the Netherlands. So basically, I'm going to point to a few of the key things of this particular ruling, as well as looking ahead a little bit. And I'm not going to go into everything that the court said because we would be here for a hell of a long time. It's quite a detailed decision, which gives plenty of food for thought. This particular case from the 29th of Feb relates to a single land-based license for the NLO, as we heard, which basically gives a license for 3 different forms of land-based gambling. And the court considers how this may no longer be justifiable in light of the opening of the remote market with an unlimited number of licenses for remote operators. Back during the Casino Operations Summit, when I briefly spoke about this case, René Janssen from the Gambling Authority informed the audience that they had obtained, they had appealed the decision and had obtained a preliminary ruling, or a preliminary injunction, which basically suspends its effects until it's been decided upon the merits. So for the time being, we will have to wait a little longer to see what happens next. I think the title of this slot refers to the last of the land-based monopolies. I should also point out that this decision only relates to some of the land-based monopolies and not all of them, but clearly it will have implications across the board should the decision be upheld. So this, just to reiterate, this decision relates to the monopoly licenses for sports betting, instant lottery and lotto, all held by the NLO. And as such, it doesn't touch upon or directly anyway, the license, and the monopoly status, rather, of Holland Casino, which, as you all know, has 14 venues. And neither does it directly touch upon the single license for land-based horse race betting, which also sometimes, I think, gets a little forgotten in discussions. And it's also about whether, we should realize as well, it's also only about whether the single license approach, the monopoly approach, is tenable, and it's not about privatization as such. Although the issues privatization and a single license often sort of crisscross each other in debate, this particular case is only about the single license and whether that's viable in light of EU law. So what happened in this particular instance? In short, the court found that the authority's rejection of JVH's application for the land-based monopoly licenses was unfounded because the authority did not sufficiently establish why a single license for the 3 regimes or the 3 forms of land-based gambling were necessary. And therefore the court held, and I don't want to get into too much jargon, but that the regime was not horizontally consistent. And therefore, the restriction, so just 1 license for each form, a single operator for each form, was disproportionate and could not be justified. And it's also very clear from the decision that the question of whether the overall Dutch gambling landscape is horizontally consistent must also be seen in light of developments, and this flows from EU law, and therefore, in this particular context, the opening of the licensed remote gambling market. And I think the underlying question here is, has the introduction of the legal remote gambling market with an unlimited number of licenses sort of undermined the viability of the monopolies in the land-based sector? And the requirement that restrictive measures, such as having 1 license per segment, is coherent and systematic, doesn't mean that all market segments have to be regulated in exactly the same way. However, there needs to be a degree of consistency across all segments. And this is where the notion of horizontal consistency comes into play. To put it simply, subjecting a less risky form of gambling to regulatory measures, such as monopoly, which are more restrictive for market operators then regulatory measures which apply to the riskier forms of gambling, such as an open licensing regime, will lack the necessary degree of horizontal consistency. And therefore, the more restrictive measure, the monopoly, will be found to be in breach of EU law. And as I mentioned before, when looking at whether a measure is consistent and systematic, whether the measure is proportionate, national courts have to take a so-called dynamic approach to this assessment. And as the regulation of the market evolves, these changes also have to be taken into account when assessing whether a restriction is consistent and systematic. And so therefore, the developments in the past 3 years since the opening of the market are clearly of importance. So a measure which perhaps 5-10 years ago would have been considered proportionate might no longer be proportionate today, given the changes to the licensing of remote gambling. And so whilst single licenses for lotto games, for example, or sports betting would have been horizontally consistent in the past, it's not surprising that the court has taken a different approach in light of the opening of the remote market. And the district court, as I just said, was very clear on this particular point. And the NLO's license is clearly, single license is clearly disproportionate. So what could the potential consequences of this decision be? Well, ultimately, it could lead to the unraveling of the land-based monopolies, at least those which are subject to this decision, and perhaps also other land-based monopolies which are justified on similar grounds. That is, of course, if the decision is upheld on appeal, which we'll have to wait and see. The district court also gave the gambling authority 12 weeks in which to take a new decision, which of course has been suspended for the time being. So if the authority's appeal is ultimately unsuccessful, the NGA will not be able to avoid having to redo its homework and reconsider its earlier reasoning to see whether there are grounds to consider whether the difference in approach, the open license and the monopoly license are perhaps tenable, can be both exist alongside each other. Although one could, when looking at the reasoning of the district court, it's also questionable, perhaps, whether the gambling authority would be able to come to a decision or to come to some reasoning which upholds the status quo. And looking at the decision in detail, you could also ask yourself whether the district court really has left the gambling authority with no room to maneuver and no space within which it can successfully argue that the land-based, the single licensing system should be maintained. There again, we don't know what the Council of State will say within, I hope, maybe some in the coming months. And this may or may not change things completely. It may provide the gambling authority with a few lifelines, or it may not. We will have to wait and see. But the underlying question will be whether the earlier notion of horizontal consistency means that there is no room for a land-based monopoly now that the remote market is subject to an unlimited number of licenses. But in some ways, the gambling authority is something of a tricky situation, because it was not the gambling authority which decided that there can only be a single license, for instance, a single for lotto and a single license for sports betting. These monopolies are all based in primary legislation. And in some ways, it feels like we've been here before, but the situation is somewhat different. Around 8 years ago, the gambling authority held a policy that it would not increase the number of licenses awarded in the charity lottery sector, those licenses awarded on the basis of Article 3. And this policy was challenged by Lot8 as it wanted to enter this particular segment of the lottery market. And given the success of Lot8, the gambling authority relinquished and abandoned its policy. But that was relatively easy, not wanting to put it too lightly, but that was relatively easy for the gambling authority because there was no limit on the number of licenses in primary legislation. And that contrasts to the current situation. So it could well be that the gambling authority is stuck between a rock and a hard place, given that the changes which would be necessary to award more licenses and to remove the monopolies would be a matter for Parliament, for the legislator. And this situation is perhaps somewhat reminiscent, for those who were in the industry in the Netherlands many years ago, to the situation back in 2011, when the Council of State ruled that the lack of a transparent licensing procedure for the award of De Lotto's license for sports betting was not justifiable and therefore in breach of EU law. That meant that De Lotto's license at the time was at risk, and I'm going to skip over a lot of history and so forth back in time. But ultimately, De Lotto's governance was amended so as to justify and therefore support and uphold the lack of a transparent license award process. But that didn't change, let's say, the underlying foundation of De Lotto's monopoly as such. So if De Lotto's governance hadn't been amended, there would have to have been a transparent license allocation process, and that would have resulted rather in another license, that would have resulted in the license being awarded to another party. But that's the point. It would have been awarded to another party, a single party. It wouldn't have been awarded to multiple parties. And that is where, and so whilst that process was amended, or could have been amended rather, there was no need to amend the underlying primary legislation. But if we get to a situation where the single license regime is not tenable, then the primary legislation will have to be amended. And so this probably explains why the District Court found it necessary to give the legislator some homework, of course, assuming that the case remains as it is upon appeal and isn't diluted or amended in some way by the Council of State. And interestingly, towards the end of the ruling, of the decision, the District Court reiterates that the monopoly model for the three forms is not proportionate, because the general objectives underlying gambling policy are not guaranteed in a systematic and coherent manner. And then the court states that it is the role of the legislator to restore the balance in the Dutch gambling regime, and that calls upon the legislator to consider the current, the spirit of the age, the way things are going at present, the entry into force of the remote gambling regime, which of course has led to a seismic change in the landscape, and the effects of those reforms upon the market. So this is, in a way, the court saying, well, maybe legislator, you need to go away and change the primary legislation. Now, changing the primary legislation to allow for more licenses would not necessarily result in the privatization of the NLO or, let's say, Holland Casino at a later stage. But I think if the District Court's decision is upheld upon appeal, this will definitely add further weight and pressure on not only, clearly, the end of the monopolies, but also the privatization of the two monopoly operators. And as we all know, back in 2019, the plan to break up the casino monopoly was sort of sacrificed to enable the remote gambling reforms to pass through Parliament, or through the upper house, I should say. They'd already gone through Parliament at that stage. So we've been there before for Holland's Casino, or for the casino monopoly, I should say. But at that stage, even though the casino monopoly was going to be broken down, space created for new market entrants, the objective of that legislation at that point in time was not the privatization of Holland Casino. That would have been a separate project, a separate development at a later date. I can see the time is ticking, and I know the other panel are eager to start on time. But what I also want to point to the fact is, back in December 23, at the end of last year, the State Secretary of Finance, as well as the Minister for Legal Protection, pointed to particular routes for privatizing the NLO. But these discussions, of course, haven't really come off the ground in this particular phase, given the elections which took place last November. And so we'll have to wait and see who takes which roles within the new cabinet, within the new government. Finally, they're getting their act together in that regard. And then this will be a matter for Parliament to pick up. So we'll have two processes potentially taking place. One, reforms to remove the single license approach, at least for these forms of gambling which are subject to this particular decision if it's upheld. potentially also, therefore, for Holland Casino, as that will also be difficult to justify if these monopolies fall. And then, parallel to that, or maybe at a later moment in time, there will also be the need to discuss the privatization of these monopolies, these providers. But of course, there are also state-owned entities active on markets where there's competition, the remote market being a good example. So we could end up in a situation where the monopolies broke down, the monopolies fall, but the state-owned operators remain and privatization doesn't take place. I think that is, in essence, what I wanted to say. I can see the time is ticking. So maybe next year we'll have a better idea as to the direction in which this is going to travel. But this decision has certainly put the cat amongst the pigeons, so to say, and puts the pressure on, to a degree, the Gambling Authority, if it's upheld, but also on Parliament to go away and look at the viability of the monopoly-based regime in these particular land-based sectors. So I think I will leave it there. I can see there's 2 questions.